Welcome. I'm Abby Gershenson, and on behalf of Leslie Griffel, I wanted to thank you for joining us tonight for our Toolbox for Aging series. The series was organized by the Social Services Committee of the Jewish Federation of Lane County, and it's co-sponsored by Temple Beth Israel. As you saw, the series is intended to cover vital topics of interest to our Jewish community as we age. Tonight are going to be the legal aspects, and future sessions for the next 3 Wednesdays are going to include next Wednesday, April 26th, is independent living and residential care, and that covers assisted living, memory care, adult foster care, independent living, and that will be presented by my colleague Willow Cordain of Willow Care Consulting, and I'll be here as well. The following Wednesday, May 3rd, is Jewish Views on Death and Dying, and that's presented by Rabbi Ruchi Motzkin-Rubenstein. And then the following Wednesday is May 10th, and the last part of the toolbox is hospice care. It's presented by Kim Dunn from Brighton Hospice. And then part 2 will be the role of the Chevra Kadisha, and that's presented by Libby Botero and Gary Tepfer. So we hope you can be with us for all of the sessions, and thank you to those who are at home and watching the stream. Thank you to Michael Griffel for volunteering to stream this on the TBI YouTube channel. And now I'm going to introduce John Ernest, who's an attorney with Thorpe, Purdy, Jewett, Ernest, and Wilkinson. And we are very fortunate to have you here, John. John Ernest graduated from Portland State in 1979 with a BS and a master's degree in business administration, and then went to the University of Oregon Law School in 1983, which is also when he graduated and was admitted to the state bar. And he joined the law firm that is today Thorpe, Purdy, Jewett, Ernest, and Wilkinson, PC. So he's been part of that firm for his entire career, and we're very fortunate to have John as part of the community, because not only is he a member of the National Academy of Elder Law Attorneys since 1993, but he's a frequent speaker on estate planning and elder law issues. And every time I hear him speak, it's an honor and a pleasure, and we all get to ask questions. He's been married to Linda for 42 years and has 4 children and 6 grandchildren. I welcome John Ernest.
Thank you, Abby. Can you hear this okay? We doing all right, Michael? Great. Thank you, Abby. It's really my privilege to get to talk to you. And when people come out for these things, it's not really that much fun to talk about the things I'm going to talk about today. But, you know, I applaud you and those that are watching on the streaming thing, you know, for getting out and doing it, because talking about things like wills and trusts and probate and powers of attorney, healthcare directives, not the sexiest things in the world, but on my way home from visiting one of my grandkids, or one of my kids this weekend, and they have 2 little grandkids, we were coming back from Medford, driving down the big curves off of one of those passes, and I was going out to pass a double trailer semi going into that one of those corners. He was in his lane, I'm in mine, everything's looking good. And then all of a sudden, he just starts drifting in right on the corner into my lane, got about 3 feet into the lane, and I am now right up against the concrete barrier that you have, you know, on that stretch of the highway. And I'm laying on my horn just because I wanted him to know where I was. So he heard it, and then he overcorrected and tried to get back into his lane, and his trailers were going back and forth and back and forth. It was, I had no problem staying awake the rest of the trip after that happened. But it just was an example to me of how quickly we can need these things that we're going to talk about today. And if we wait until that accident occurred, and it would have been really tough. I mean, if we would have come out of that, in that situation, and my wife was right there next to me, giving me the play-by-play as we were going, you know, we would have needed some of these things, our will, trust, or a power of attorney, or a healthcare directive. So The point is, we want to get these things done while we've got, a sound mind. We can make good decisions and get these, since we're calling this series Toolbox, these are really tools that all of us want to have in our toolbox. I mostly practice what I preach. I have had a power of attorney, a healthcare directive, and a will in place since the time I started practicing. I have to confess, I'm an estate planner. Abby's heard this before. I don't have a trust, but before I retire, my wife and I will definitely have a trust. But right now, I've just got too many other clients to take care of, and we haven't gotten around to it yet. It's definitely a good idea to do, and we're going to talk about that today. So, as Abby said, I've been with our firm for over 40 years. Our firm does a lot of this type of work. Our information is on the back of this outline. That's not really why I'm here. I have lots and lots of clients, although I still occasionally am able to take on new clients. Our firm takes on new clients because we do a lot of this kind of work that we're doing today. But if you have an estate planning lawyer that you have met with, I always encourage people to stay with that lawyer that they have a relationship with. And what I'm hoping tonight is that you'll end up with a few good questions for your lawyer. And you'll know a little bit more about these legal tools that all of us really ought to have. So that's what we're going to kind of cover tonight. And we're not going to make you experts on these things, but hopefully we'll make some of these things maybe a little more understandable. I think we'll just jump in and get to work on things. So I have this outline mostly to keep me on track, and then you can kind of follow along as we go. I like to take questions as we go. Chances are, if you have a question, there's somebody else in the room or on the streaming thing that has the same question. If we get bogged down and I don't feel like, that it makes sense to stay on that question, I'm going to stick around when we're done for as long as anybody has a question. Okay, so the first topic we're going to talk about, and the two tools that we want to have in that tool belt, are a power of attorney and an advanced directive, okay? So a durable power of attorney, you've probably all heard of that. I would guess that at least half of us in the room have a durable power of attorney, or maybe you've used that for a parent. What a power of attorney is, simply, is that it's a written document where you're called the principal, name somebody else, they're called the agent or your attorney in fact, and you give them authority to do certain things on your behalf. And a power of attorney can be as narrow as you want it to be. It might be to only do your banking or only sell your home, or it can be very broad. When you're doing a power of attorney in the estate planning context, you usually want it to be broad. If we would have got in the bad wreck and I was incapacitated, I have my wife as my power of attorney, but one of my sons is the backup. And I want him or her to be able to do everything financially for me that I could have done for myself before I was incapacitated. So in an estate planning context, we usually want to have that to be very broad, okay? Form powers of attorney that you can get off the internet, in my opinion, are better than not having a power of attorney at all, okay? If you're doing your estate planning, the additional cost to do a power of attorney is next to nothing. So if you're doing a will or you're doing a trust, usually your lawyer's going to suggest that you get the power of attorney done at the same time. It's really just a form that the lawyer has developed over the years, and they're going to plug in your name and your decision makers, and so it's very easy to do. If we don't have a power of attorney, I get in that wreck and I can no longer take care of my financial stuff, then somebody from my family is going to court to be appointed as my conservator, which is in effect a court-appointed power of attorney, okay? That is something we don't want to, put ourselves into because it's expensive, and if that would have happened and I had a conservatorship, that's going to go till the end of my life. And my conservator is going to have to be bonded. That cost is coming out of my estate every year. The conservator has to file an accounting, and a lawyer is typically going to have to do that to get it done right every year, and that's going to go until I die. If I have that power of attorney in place, it's going to avoid the conservatorship, 99% of the time. So that very simple document, we get that in place, you've made your decision, that's going to very often avoid that court-appointed conservatorship. Now, if we never lose capacity, we never need the power of attorney. But if we lose capacity and we don't have a power of attorney, then it's too late. Then we're going to court to get that conservator appointed. We do that work. We try to avoid it if at all possible, but I probably do a conservatorship at least every couple of months. And it's almost always because the person didn't have a power of attorney in place. It's true even in a husband and wife situation. If I was incapacitated and my wife was fine after that wreck, if I didn't have a power of attorney and she needed to get money out of my retirement plan, she'd have to go to court and be appointed as my conservator. So it doesn't, just because you have a spouse doesn't mean they're going to automatically be able to step in there and take care of those things for you. Okay? Healthcare directives. That's a second tool that we all want to have in our toolbox. Oregon had an outstanding advanced healthcare directive form for about 30 years. We started doing it in 1993, and of course, with the wisdom of our legislature, they decided we need something new, and so at the beginning of, not this year, last year, they passed 2 different forms that took its place. If you have an old advanced directive like I do, and you like it, and it says what you want, you don't have to change it. But if you do one now, a new one, you have to follow one of the new forms. And there's 2 forms. One is, the reason I like the old form is that it was relatively simple, and it did 2 things. It said who made your health care decisions if you couldn't make them, and then it had an alternate for you to name. The second thing it did is it pretty simply allowed you to give directions about end-of-life care. If you are in a coma and it's very unlikely you're going to come out of it, do you want life support? Do you want tube feeding? Do you want those things? So if you have an old one, great, keep it in place if you still like what you have in there. If you do a new one, you've got to use one of the new forms. The new forms, there's a short form that is called an appointment of healthcare representative, and that's all it does, is it says, if John can't make his healthcare decisions, this is the person that I name. In my case, I would name my wife, and then I would name an alternate, one of my kids. And that's all it does. And for a lot of my clients, when choosing between that and the more complicated form, and I actually brought the complicated form and left it for you out at the table as you go out, if you want to have it to just review it and look at it, it is the statutory form for doing a new advanced directive where you give a lot of end-of-life instructions. So if you can look at that, and then you've either got that choice or you have the more simplified document. And that's what you would do today. That document does the same. It also appoints a healthcare representative, but the second part of it gives a lot of different healthcare instructions. So I'd say, probably 80% of my clients like the short form, and maybe 15 to 20% are going for, opt for the more complicated form, and 5% get confused by it all, and I can't talk them into doing it, and they don't do one. So we want to have that in place. If we don't have one, I get in that accident, my wife is fine, but I'm not, and healthcare decisions have to be made for me. I might have to be placed in a care facility, and I'm refusing, then my family's going to court to get a guardianship over me so those decisions can be made. If I have a healthcare directive with instructions in it and a decision maker for me, then most of the time we're going to avoid that court guardianship. And the guardianship's a little bit like the conservatorship. Once you have it, it goes till you die or until you regain your capacity. And it's expensive to do either one of those, a guardianship or a conservatorship. And the cost of that, that's coming out of my pocket if it's for me. It's coming out of my resources. So, and when I say expensive, even if it goes very smoothly, you're looking at, usually $3,000, $4,000 just to get those things in place. It is a lot less expensive to do a power of attorney and a healthcare directive, so that's why we want to do that. A few miscellaneous things there for you. I've already said this, but they're inexpensive and easy to do. You can get these done on your own if you don't have an estate planning lawyer that you're working with. get a power of attorney in place, get an appointment of healthcare representative, and that is something you can do. The instructions, if you follow them, are pretty clear. Second thing, you've got to have, I've already said this, capacity to do those documents. If we wait until we've lost capacity, it's too late. And I also would just mention that sometimes clients think their spouse or their parent, you know, they're not doing very well and they don't have capacity to do this. But if they have capacity at the best time of day for them, then we can still potentially get that document in place. So you've got to understand the document that you're signing at the time you're signing, and that's really the test, okay? Couple things I really like. I've already kind of said this, but it allows you to appoint who's going to make your decisions rather than the court. The court is going to do their best, but you're the one that knows really who the best decision maker would be for you. I've already said this, but it allows decisions to be made within your family and without any court intervention. I say down there in a little bit, you want to have an alternate. I routinely see these documents, especially powers of attorney. I just saw one with a client I met with this week where they named the spouse and that was it. Their spouse died. And now they don't have capacity to name their only child, who should have been named as the alternate. If she would have been named as the alternate, we'd be in great shape. Now we're probably going to court to get authority for the daughter, who's the only logical person and very responsible, happen to know her personally, and I didn't do the documents, or I would have made sure there was an alternate in there. And now we got to go to court to be able to get these things in place for her mom, who's lost capacity. So make sure we get that alternate in there. First choice and a backup. Couple other quick things. You can change it. So if your circumstances change, you can revoke your power of attorney, do a new one, put new decision makers in. I missed number 5, and that's the most important thing. You've got to have total trust in who you're naming as your power of attorney, because they're not going to be monitored by a court. They're not going to be monitored by anybody other than, you know, somebody that cares about you. And so they can do a lot of damage if they're not trustworthy. So if you don't have that person in your life, then don't do a power of attorney, because then we'd be better off with the court appointing somebody, because then the court would oversee that. Okay. Last thing there is that document terminates on death, so you can't use a power of attorney to administer somebody's estate after they have died, because when you die, your power of attorney dies. And, one last thing that I didn't put on the outline, and that is, same power of attorney I saw this week was only effective upon 2 physicians saying that, in my example, that I was incapacitated. So before that power of attorney can be used, we got to get 2 doctors to examine me or know me and say, Ernest has lost the ability to take care of his finances, and that makes it a real hassle to use that power of attorney. So unless my client insists, I always make powers of attorney effective when you sign them. Okay? Because if you don't trust the person that you're naming to not start doing stuff for you until you need it, then you shouldn't be doing a power of attorney naming that person anyway. So make it effective immediately. Okay, so far so good. Any questions about powers of attorney and healthcare directives? Yes?
Do you recommend that the person that you've named has a copy of that document? Can you say that or ask that again?
Yes.
Do you recommend that the person you're naming for both your health directive and your power of attorney has a copy of those documents?
That's a good question, and I should have said this. Obviously, you want to ask that person to make sure they're willing to do it. Okay, we don't want this to be a surprise that they get later that, oh, you're power of attorney for Dad. My preference is that my client keep the documents and let their agent, who they've named, let them know where the documents are. And then if my client wants to give them a copy, great. Personally, I haven't given a copy to my kids that I've named because they have busy lives and I know they would probably lose track of it. But they know that if something happens to Dad, they know right where my documents are and they can access them, okay? Yes,
So,
Abby?
John, this is from the stream.
Uh-huh.
The question is, what happens if you lost capacity and so the person who's your power of attorney takes over, but then you regain capacity?
Then you can, so when you have a power of attorney, you can still do everything, okay? So when we make it effective immediately, my agent could do things for me, but I can still keep, I've got a power of attorney. I'm doing all my stuff. If I was temporarily incapacitated, then my agent can step in and take over for me. If I regain capacity, I can start doing stuff again, okay? So that's the answer to the question. Okay, yes, sir.
Very quickly, I want to make sure I understand. If you have an advanced health care directive and you change it in any way, add someone else, you have to start all over again, do a new one?
In my opinion, yes. You know, when we do these documents, we don't want to mark them up and change a decision maker, because when you execute these documents we're talking about tonight, they've either got to be notarized or witnessed by 2 witnesses. And so if we make a change on it, it just makes things confusing. You could technically, on a will, you could change something and then you sign it and you have 2 witnesses also sign it, again at that point. But that's just too confusing. So I would redo the power of attorney or the healthcare directive, and then I think what you're getting at is then you have to use the then current form. So you can't just go back and amend your 2015 advanced directive, because when you do one now, you've got to do one of these 2 forms that the legislature has passed. Okay? Other questions on those items? Powers of attorney, healthcare directives. Okay. How are we doing, Abby, for time? Is there a clock around here? I don't. Okay. I'm not going to run over, but I also don't want to be like a half hour before. Okay. We're going to jump into the next topic. And so we're going to page 2. We're going to talk about 2 more tools to have in the toolbox. At least one of the 2 you ought to have in there. So almost all, I want to say all of us, pretty much all of us, you know, you at least want to have a will in place. Your other estate planning option to say what happens to your stuff and your money and your house when you pass is to have a trust. You know, those are really our 2 main estate planning tools. When I started doing this 40 years ago, I would say 95% of our clients would do wills. That was just really the most common estate planning tool. And over time, the trusts have become much more popular. And I think part of the reason for that is is what we're going to talk about first, and that is when we have a will, when we die, usually it has to go through the probate process to get your assets transferred to who they're supposed to go to. And the cost of probate has just, you know, gone up and up and up. It's more complicated, it's just more expensive, and it seems to take longer no matter how efficient we try to be with it. So you're looking at, you know, if I do a will, if my wife and I had died in that accident, my son Matt would have been filing the will with the court, getting appointed by the probate court, and then he could have carried out everything that was in our will, okay? I just happen to know that Abby has a trust. In her situation, her decision maker is not going to court because the trust doesn't have to go through the court probate process. So that's really the main difference. I hope that I shouldn't, I probably shouldn't have said that, Abby, but we've discussed this a lot, this topic, and she's listened to this talk so many times she could give it herself. You know, so it's really the main difference between doing a will and doing a trust, is that the trust is going to avoid probate and a will generally is not, okay? So let's talk about probate, what that is, and, you know, what we need to know about it. So probate is the court-supervised process of having the assets of somebody who has died that has assets in their name only, it's the process of getting those assets distributed to who they're supposed to go to. That's going to be set out in your will. After the bills are paid and tax returns have been filed and the court has approved that distribution. That's what probate is. So, if Linda and I would have, died in that accident, which we didn't have, thank you, we would have had a probate at that point. And a probate these days, in our situation, we would have had to have a full probate. You only can do a small estate, which is a simplified probate procedure in Oregon if you have a home or real estate that is worth less than $200,000. These days we don't run into too many of those. Occasionally we do. And your personal property and your money, the total of that has to be under $75,000. So not a lot of estates qualify for a small estate. Okay? Yes? Is that different than a residential trust that you're talking about? Say that again? Okay. Okay.
So is that different than like a residential trust when you said that it has to be $200,000 or less? Can a residential trust be for property more than that?
Yeah, it is any real property. So if we have a home, and I have an estate right now where the home is not in very good shape, so it's under $200,000, and we've done a small estate. And it is a residential home. But it would apply whether it was a residential home or a commercial property. You got to be under $200,000 to do the small estate. So most of the time when we're doing a probate of somebody's will, it's a full probate. Okay? So if we're over either of those limits, property is over $200,000 or personal property and money is over $75,000, then we're doing the full probate. The cost of doing a small estate usually ranges between, it's fairly reasonable. It's maybe $1,000 to $2,500. It's over in 4 months unless there's something unusual that's happening in it. A full probate is going to take typically 8 months to, we try to get them done within a year. Otherwise, there's another filing fee and there's more things you have to do with the court. And I would say these days, I'd like to go back to when I did this talk 25 years ago to remember what I would say, but it was not $5,000 to $10,000 to do a probate. It's just really gone up. Just the filing fee and the out-of-pocket costs are close to $1,000, and then most of those fees are the attorney fees that you have to be able to get a probate done in Oregon. And then if you add in the fee that your personal representative gets, it can be even a lot higher because that's based on the value of your estate. And your personal representative is usually going to be a family member that you've named to be in charge of things. Okay? So that gives you a little bit of a flavor for the probate, what it is, and why you might consider wanting to avoid it. Okay?
So
Huh?
the probate, you have a personal representative.
Yes, so the question was, with a probate, do we have a personal representative? You do, and in your will, you say who that's going to be. But the court has to appoint them before they have any authority. So your will by itself does us no good until we give it to the court, and the court says, Matt's appointed as the personal representative, and now he has a document. They're called letters testamentary that shows he's the personal representative, and then he can sell the home, he can go, collect bank accounts, get everything into the estate, pay the bills, and at the end of that probate, the court says, okay, Matt did everything right, got the tax returns filed, got the bills paid, collected everything that needed to be collected, and now we can distribute it out to, in my case, our 4 kids. Okay?
So it's So in a way, it's like a trust, except that you have this intermediary court and a lot of expense.
Very well said. Very well said. Because Your trust isn't going to go through that probate, but you've named somebody like a personal representative, but in your trust, it's going to be your successor trustee. And we'll cover that in just a minute. That intermediary doesn't have to go through the court. They're going to do everything outside of the court, okay? And your trust is going to tell them what to do. Just like your will tells the personal representative, the trust tells your successor trustee what you want to have happen and who gets what. They just can do it without having to go through the court system, okay? And that is why revocable living trusts have become a lot more popular these days. And they're a great tool in the right circumstances, and a lot of my clients, that is the right thing for them to do. But it isn't, not everybody needs one. So it's one of those things where I think you go to your estate planning attorney, they help you figure out what is the way to go based on what your, priorities are and what you're wanting to do and what your estate consists of. And it's often a very, very good way to go. We're going to talk about that here in a minute. I want to quickly go through the requirements for a valid will, so you know what it takes to have a will that is valid, because that is another thing that I see a fair number of wills that are done do-it-yourself that are valid, that will work. If you get fairly complicated, then it goes down quite a bit on how good a job was done. But if it's fairly simple, you've got kids, not lots of kids from, other relationships. You're not providing for maybe a child with special needs. But I've seen a lot of wills that have been totally fine that somebody did off, a form from the internet. Do I think that's a great idea? I don't think so, but I'm just saying I'd rather have somebody that has a will with some direction than have nothing at all. Because if we have nothing at all, the state of Oregon has a will for you. There is Oregon law that says what's going to happen to your estate. It may be what you want, but it also may not be what you want. And I probably, end up probating at least 4 or 5 estates a year where we had no will. So it's Oregon law that's going to determine where that person's assets are going to go. Okay, so the requirements for a valid will has to be in writing in Oregon. It has to be signed by the person making it. It can be done with a mark. It can be done with a stamp. But if you do that, then there's a special way of, witnessing it, okay? If the person can sign, even if it's a bad signature like mine, then all we got to do is have 2 witnesses, watch me sign it, then they need to sign the will, and we've got a valid will, okay? So it's in writing, signed by the one making it, witnessed by 2 people. And the witnesses need to sign at the time you sign. Otherwise, if they, after death, they can't go back and say, oh yeah, I witnessed John sign that. That does not work, okay? And if the will is invalid, let's say, because I see this every once in a while, somebody goes, they do their own will and they get it notarized. And that's it. That's not valid because we don't have 2 witnesses. We just have the notary and that's it. So I've been able to get those wills since Oregon passed a law in 2014 that allows us to get defective wills accepted by the court if we can really prove that that was what that person intended to do. So if they've signed it and we have a notary, that's pretty good evidence of that, and our court's been pretty good about accepting those. If they did it with a lawyer but didn't sign it, I haven't seen one of those go through yet. You got to at least sign the thing. So that's a good thing, I think, that the legislature did when they passed that. Okay, we're going to talk about trusts a little bit more. Let's just say how a trust works. A trust is going to look very similar to a will. Usually they're going to be a little longer, but they don't have to be. But it's going to look like a will. It's going to say, if I had a trust, it would be probably the earnest living trust or the earnest revocable trust. My wife and I would probably be the trustees to start out with. Usually you would provide, if I died, she'd be the trustee. When we both can't do it, it would be one of our kids. And I always like that, lawyers love alternates, and so should you, because we want to have backups in case something happens. So, I'd have one of my kids as the backup, and I'd have another one as the backup. And I would pick the kid that is the best for the job, not my oldest son, not my, closest child that lives by me. I'd pick the one that's going to do the best job of administering my will or my trust. Or on my healthcare directive, it's the one that has a background or would be best dealing with difficult healthcare decisions. So we always want to pick, we don't want to worry about feelings. And when my wife and I did this with our kids, I told them, these are not jobs you really want to have, because that means mom or dad, they've either died or they have become incapacitated, and now we've got tough decisions and a job to do. So we're just picking who we think can handle that the best. And that's how you want to do that. And always have a backup. So we're going to do this document called a trust, and then the way it works so that it avoids probate is that it's an entity of itself. It's like establishing a corporation or an LLC where it can own things. Your will can't, but your trust can. So I deed my home into the trust, so my trust owned it. I would transfer my bank accounts so that my bank accounts were owned by the trust, or at least have the trust named as the beneficiary. My first choice is that the trust actually owns the bank accounts. If I had a brokerage account, I would retitle the ownership from my wife and I to us as the trustees of our trust. If you had other property, you would deed that into your trust. And so the way it avoids probate is it's now the trust owning your property and not me and my wife. And the trust keeps going if we both die. So if we both die, the trust says, Matt's now our trustee, and he can go in and he can sell things, collect things, pay the bills, get the tax returns done, do everything that you got to do in a probate, but we do it without the court having to oversee all of that. So it's a lot less expensive. It is almost always faster. And, so that's why it is a popular tool to use. And I have had people that have had bad experiences with trusts and trust administrations. Usually the complaint is a trustee that's not taking care of business, and they're letting things go and go and go. And so we don't have a court that is automatically monitoring that. Whereas in a probate, you do. If I don't have things closed within a year, then it used to be Judge Holland, now it's Judge Conover. They're going to say, Ernest, why hasn't this case been closed yet? And you've got an accounting due to tell me everything that's been going on with this. And it's, they're hollering at me, which doesn't happen, okay? But they would. It's really my client that's the one that's in trouble, but we're going to be going to court to explain that. With a trust, you don't have that, force of the court behind it. So you can complain to your trustee that, why is this, it's 3 years and this isn't wrapped up yet. And, so those are the only times that I've really heard complaints about, I wish this just would have gone through probate instead of this trust. Most of the time, I'd say 95% or more of the time, people are more satisfied with that experience. And it certainly costs less at that point in time. Okay? We're going to give an opportunity for questions on this here in a second, but a couple things for the trust to work smoothly. Having, kind of as I just alluded to, a competent and trustworthy trustee that's going to get business taken care of. We want to name that person that's going to do the best job of getting that taken care of after my wife and I have died. And the other thing is we got to make sure that we get our accounts and our property into the trust and that we keep them there. If you sell your home that's in the trust, you're going to get a check payable to the trust. If we go buy a condominium, don't put them in John and Linda's name. Put it in our trustee, our trust, okay? So that's just what we want to have on our brain, is that we open a new account, a new brokerage account, we want to have it opened in the name of the trust. So in our case, if it was the Ernest Living Trust, the ownership would be John Ernest and Linda Ernest, co-trustees of the Ernest Living Trust. So you want to get in that habit, okay? The other thing I would just throw out real quickly about probate and what have you is that another common issue that we run into is where people have a life insurance policy that they've kind of lost track of. They named their spouse as a beneficiary, but their spouse died. And now we have a life insurance policy that's going to pay out $25,000, but no beneficiary. So in that case, we've got to do a small estate. $25,000 asset, we can collect it through that small estate, but it's still going to cost, $1,000 or $1,500 to get that done. If we have a beneficiary designation on that, there's not going to be a probate. So if we have a trust, we want to make sure our real property, our bank accounts, that sort of thing are in the trust. But things like retirement accounts, we just got to make sure we have our beneficiaries on it, because you don't transfer your retirement accounts into a trust. You can't. Your retirement accounts have to stay in your individual name. So assets have to be in the trust or have a beneficiary on them, and then we're going to avoid the probate. Okay? That's a lot. Let's slow down there for just a second and see if we have any questions about the wills or trust or probate. Yes?
So you're saying the only situation where we can name beneficiaries is retirement accounts? We can't do anything else as a beneficiary, if they have an investment account?
See, this is why we take questions, because I wasn't clear, obviously. You can put beneficiary designations on just about any financial account that you have today. So I'm glad you asked that. You can put beneficiaries on your retirement accounts, and you really need to have your beneficiaries named on those, okay? If you have kids, usually it's going to be your kids. In my case, it's my wife first, and then it's my children. But in this, let's say we have a client who they don't have a home, they haven't done a will or a trust, they live in an apartment or retirement living, and they have a substantial brokerage account that's not a retirement account, and they have some bank accounts. They can avoid probate by just putting beneficiaries on those accounts, like what you're thinking. So you can put a transfer on death designation on your brokerage account. So if you have a Charles Schwab account or a Vanguard account, you can set that up so it's TOD, transfer on death, to your kids, and then that avoids probate. You can set up any bank account, savings, checking, money market, CD, so that it has a beneficiary. You can make those payable on death to who you want them to go to. So in that simple example where I could have somebody with $1 million estate, and as long as they have beneficiaries on those accounts, they're going to avoid probate, and those accounts are going to go to them. And I've done that where I have somebody, they've got a nice estate, but they don't have any real property, so we can avoid probate by doing those beneficiary designations. The more complicated the estate, the more kids, the more property we have, the trust is usually a better vehicle, because it's also kind of hard to keep track of, if we just do beneficiary designations on accounts, then we've always got to make sure we've got those updated the way we want them to be. But you can do it. So that's a good question. That's the answer. Any other questions on the trust, will, or probate stuff? Yes, Abby.
Sorry. So I'm going to read a few from the live stream.
Okay.
Okay, so the first one is, let's see, what about transfer on death designation on stocks, etc.?
So that's really what we were just talking about. When you do that on stocks, the only way I see it work well is if it's in a brokerage account. So you have stock in a Merrill Lynch account or a Charles Schwab account, and it's very easy to make a transfer on death designation on that. And just make sure that you name the beneficiaries that you want to receive it. So quick example, I run into this all the time where parent names the oldest child as the beneficiary of their retirement account and have given them direction to share it with the other 3 kids. Well, if they're the only beneficiary, it's all going to them. They get to pay all the tax. Okay? That's not good. And now we somehow got to figure out how we're going to divide it up with the other 3 kids. So I run into that. Instead, name the 4 kids as the beneficiaries on that transfer on death account or on that retirement account, and then that's going to smoothly have that go to them with no probate. Okay? You kind of asked that question.
Yeah, thank you.
Yeah.
2 more.
Uh-huh.
So, excuse me, if you have a primary residence in another state
Uh-huh.
and have a trust, but die or become incapacitated in Oregon, will the trust be honored?
Honored? Yes. So let's say we have client that lives here in Oregon. They have an Oregon home, but they have a vacation home in Arizona. We do a trust here. We put the Oregon home in the trust. We can also put the Arizona home in this trust. And if that client then dies, we're avoiding probates in both states. So that's a time when I am, pushing the client to do the trust, because then the trust is going to really have a double or a triple benefit depending upon where the properties are. Because if we have homes in 3 states and we have a will, we're going to have probates in 3 states. The Oregon probate won't control a California home or an Arizona home. Okay? I think that answered the question.
Yes,
Okay.
thank you. So if somebody has real estate outside of Oregon, that's a good reason.
It's an extra reason to consider doing the trust.
So the last question, I think I may know the answer to this. If I choose to do a will, do I need 2 signatures and notary? So my understanding from listening to you
Be
is...
careful here, Abby.
You
Go
might
ahead.
ding me. That I need 2 witnesses, but I don't need a notary for
You're
the
right.
will.
You're right. Now, what usually happens is we have the 2 witnesses. The witnesses' signatures have to be notarized. There has to be an affidavit of attesting witnesses. If you have a will, if a lawyer did it, almost always, you're going to have the witnesses signed, then there's going to be another page that has a notarization of the witnesses, not of the person that made the will. So when we do it in our office, our witnesses sign, and then our notary notarizes us. But Abby's correct. All you need to have at the time of the signing is the 2 witnesses, and that's it. Okay? And when you execute a trust, because we didn't cover that, some lawyers will have it executed like a will with 2 witnesses. There isn't a requirement of that, so we have our clients sign it, and we just notarize that signature is what we do. And I've never had that challenged or contested. Okay. That's it on that? Okay. And how are we doing for time? Because I totally lose track of that when we're 7:48. And okay, so we're doing good. Okay. Okay, good. There was one other thing that I thought of there, and that's the bad thing about getting old, is that it might come back to me when we start talking about gift and estate tax. Okay. Okay, so the next section, I like to talk about gift and estate tax a little bit. I'm not the expert on it, but know enough to kind of give you the basics on it. And I find it to be one of those areas that is just really misunderstood out there. What is gift tax? What is estate tax? When does that, get paid? And, roughly what are the tax rates, that type of thing. So again, I'm not an expert on it, and we're not going to make you experts on it, but I think that, hopefully this will be somewhat helpful. So what's the difference between gift tax and estate tax? That's pretty easy. Abby could probably answer this because she's heard it before. Gift tax is tax that we pay on a gift when we're alive. Estate tax is tax that is paid by your estate after you have died. So that's the difference. Gift tax is when I give something that was taxable and I'm alive. I have to pay gift tax on it, and we're going to explain when that happens. Estate tax would only be after I died and there were distributions from my trust or my will and my total estate was a certain amount. We're going to talk about that here in a second. So that gives you the difference between gift tax and estate tax, okay? Gift tax, we'll take the part while we're alive. In Oregon, there is no gift tax. You could give $1 million to your kids and pay no gift tax. You have to report it, and most of you have probably heard if you make gifts over a certain amount, you have to report that. But what is highly misunderstood is that most people think if I give gifts over this amount, I have to pay tax on it. And it's just that you have to report it. The amount that you have to report is if you give more than $17,000. That just went up this year from $16,000 to $17,000. If I give more than $17,000, say, to each one of my kids, then I have to report it in the form of a gift tax return to the IRS, but I would pay no tax on it, and my kids would pay no tax on it.
Not federal either?
Not federal, right. Oregon has no gift tax. The only time you would pay gift tax, okay.
Sorry, people are asking to repeat.
Sure, you bet.
I just wanted to ask, you said there's no Oregon gift tax. I was just affirming that there's no federal gift tax either.
Okay, there can be federal gift tax. That is if, for a single person, the gift tax estate exemption for a single person at the federal level just went up to $12.94 million. So I don't have any clients that have to worry about paying federal gift tax. If they make a gift of more than $17,000 to an individual, then they have to report it, but there's no tax on it. So why do you have to report it? It's because of the folks that have lots and lots and lots of money. If they eventually add up all those gifts that had to be reported and they get over that $12.94 million mark, then they start paying federal gift tax. They wouldn't pay Oregon gift tax because there is no Oregon gift tax, but they would pay federal. And if you're married, you each have that 12.9, I think it's 12.94, I wrote it down, 12.92, I'm sorry, 12.92. Then it gets doubled. So a couple can make gifts, reportable gifts, that are almost $26 million without paying any gift tax. So none of my clients are having to worry about paying gift tax. Yes, Abby?
I have a question.
Uh-huh.
So if I gift to a child, an adult child who's living in Washington State,
Uh-huh.
does it matter what their limit? Will my child maybe have to pay taxes on that because Washington State has a limit?
No, it is the state where the giver is that controls that, okay? And if there is a state tax, this seems kind of odd to me, but it's true, it's not the child that pays the tax, it's the giver that pays the tax. Just like my estate, if it goes to my kids and it's over a certain limit, it's the estate that pays that tax. It's not the kid that's paying it. So that's the answer to that question.
Is that over the lifetime?
Okay. That is a good question. Go ahead.
Oh, is it over a lifetime or is it over a year?
It is over your lifetime. So if you were given $1 million a year to one of your kids, after you got over the $12.92 million, you'd start paying gift tax. You would, they wouldn't, okay? On the annual thing, the $17,000 gift limit, that is an annual gift. So if I give $17,000 to each one of my kids, and my wife gives $17,000 to each one of our kids, we don't have to report that to anybody. So that goes to them. They don't pay tax on it, and I don't have to pay any gift tax. And one of the places where that comes in handy is where we're gonna talk about it next, which is estate tax. Estate tax is what our estate pays after we've died if our estate is over a certain amount, okay? The federal amount is those same numbers that I gave you, and what it is for the federal amount is it's a combined limit on your lifetime gifts and your after-death gifts is what makes up that $12.92 million that you can give away without paying any federal gift or estate tax. And that's for each person if you're married. So each of you can do that. So again, I've never run into a case when these limits went up to these amounts where I have an estate that's paying, any federal estate tax. But Oregon's exemption amount for estate tax is much less than the $12.92 million. It's $1 million per person, okay? So Linda and I each have $1 million exemption, okay? If I die and everything goes to her and we don't do anything to claim my exemption amount, we lose it. So if you're married and you have a $2 million estate or well over $1 million, then you want to do your estate planning so that you have the ability to use both of those exemption amounts, okay? And that exemption amount, I predict will go up at some point, but we've been at $1 million per person now for quite a long time. There's proposals pending in the legislature to increase that, but until it passes, we're stuck with the $1 million exemption amount, okay? So one of the things that is a very simple estate planning tool to reduce your estate tax is, let's say I'm single, I have a $1.4 million estate, and I have a home that one of my kids lives in. It's really their home, but I own it. So it's part of my $1.3 million estate. Did I say 1.4? 1.4. Let's say that house is worth $400,000. That's my child's, where they live, but I own it. If I deeded it to them before I died, I'd have to do a gift tax return because the gift was more than $17,000 to that kid. But Oregon has no gift tax, so there's not going to be any tax on it. And if I remove that $400,000 asset from my estate, get it into my kids, and I die with $1 million estate, I have no estate tax, okay? Now, you got to be careful about those things because let's say it wasn't his, it was a rental I had, and I gave it to him, and it was worth $400,000. I get it out of my estate, but now he's going to have this asset that he owns that has a really low basis in it because I gave it to him while I was living. If he would have inherited it instead through my will or my trust, then he gets a step up in basis when he inherits it. If I give it to him while I'm living, he gets my basis. So if it's a rental, it's been depreciated, I stick him with a horrible capital gain that he's going to pay tax on at a lot higher tax rate than the estate tax would have been on that excess $400,000 amount. So this is really kind of just to get you thinking. It's not, please don't go out and give away some, stock that's highly appreciated that you're going to give to your kid to get your estate down below $1 million. It's one of those things that you definitely want to do after you are talking with your CPA or your estate planning attorney. A fairly simple strategy that's a little less complicated than what I just went through is, let's say you're at 1.1 million and you've got $100,000 in money market and that type of thing. You can, if you make gifts of that money to your kids over a year or 2 years at that $17,000 amount, you get your estate down to $1 million, you've given them that money that they were probably going to inherit anyway, and now we don't pay any estate tax on that excess $100,000. The estate tax on that excess $100,000 is about 10%. So on a $1.1 million estate, if I die with that estate, that first million's going tax-free to my beneficiaries, and that next $100,000 is going to get taxed at about 10%. So it's not horrible, but it's also something that, if you know the rules, you can legally reduce that tax and sometimes avoid it. Do we have a question there?
Yes, we do. And there's
Okay.
also a request that you repeat the question. I think they're hearing you more clearly on the
Okay.
stream.
All right.
So here's the question. And again, you've spoken to this, and I think it's good for people to hear it twice because it's a question on the stream. If you gift more than the $17,000 a year, does the recipient pay tax on the amount over the $17,000?
No, but you have to report it because you've, exceeded that $17,000. We call it an annual exclusion amount. So we report it. No tax is paid by the giver, and the receiver never pays tax on a gift. Okay, so it never hurts to go over things twice with these kind of things. So I think sometimes what's happening is they're giving their question, and maybe we've covered it, but we've still got the question. So that's good. That's good. I like questions. I already other consequences of gifting, I already mentioned that we want to be careful about gifting property. Could be stock, it could be a rental that has a low basis, and giving that away before we die, thinking we're going to save on estate tax, but not thinking about the fact that our kid may, or our beneficiary, may have a bunch of capital gains tax to pay on that, which is a higher rate. Yes?
I hope this isn't going too complicated, but.
Okay.
Right into it, okay.
Okay.
If you receive as a gift the place you're living, your primary residence,
Yeah.
and you sell it, isn't it, I don't know, does it still apply that if you're a certain age when you sell it, you can get an exemption from paying taxes?
So do I need to repeat that, or do you think we got it? Okay, so the question is, when we sell our residence, if we're at a certain age or older, is there any type of an exclusion for the gain on that sale? And the answer is yes. And the rules have changed over the years. It used to be a one-time exemption, and I don't remember the exact amount. You had to be over either 55, might have been 65. Anyway, I'll give you the current rule because that's all that matters. Now the rule's better and it's simpler, and it is you can sell your home anytime. You can be 40 and sell it, and for a single person, and as long as you've owned it and lived in it for 2 out of the last 5 years, okay, so if you buy it, you've lived there for 2 years, you can sell it and exclude a gain of up to $500,000 for a married couple, $250,000 for a single person. And it doesn't have to be a married, you and your partner could buy it, and you would each have a $250,000 exclusion. So it's basically $250,000 per person that owns it and lives there, okay? So you can do that now as many times as you want to, whereas you used to be able to do it one time and that was it. So that is probably the most favorable tax rule that any of us kind of regular taxpayers have, is that exclusion on that. Otherwise, if, say, it was a rental and you sell it, you're going to pay tax on whatever your gain is. If you bought it for $200,000 and you're selling it for $400,000, you're paying capital gains tax on that full $200,000 gain. Okay? Good question. All right. Any other questions about gifting? I have one other comment, but any other questions about gifting? Okay? Yep.
It really sounds complicated to me.
Yeah.
So and you said you're not really an expert.
I would give you advice about that's a good idea or that's not a good idea, but you talk to, if you have a CPA, I think that's one of the best sources to get that information from, okay? And if you have an estate planning / tax planning attorney, they're also going to be able to really pin down, what this is going to, be for you if you do this, okay? So I would say it is a little bit complicated, but it's not, it's not horribly complicated. It's just there's a lot of misinformation out there that you hear. It's kind of like the rule that you heard of was true years ago, but now it's changed. So you just want to make sure you have up-to-date information, and it's always good to be talking to your attorney or your CPA when you're talking about these tax things, okay?
John, there's
Yes.
a question back here from our streaming audience. Does the 17K gift use up part of the $1 million estate tax that the person inherits tax-free?
Okay. So that's a good question. The 17,000 gifts don't count against your $1 million exemption. I think that's what the question is. They do not. Okay, so you can give as many of those to as many people as you want to on an annual basis, and that won't reduce your $1 million exemption or your $12.92 million exemption at the federal level. Okay? What reduces your exemption, just to kind of finish the thought, is if we give more than the 17,000, then the amount over 17,000 counts against your exemption. Okay? All right. The other quick thing on gifting I wanted to mention, because we're not really going to get into it on the last section, is that if you're helping somebody with Medicaid, which is a program that helps to pay for long-term care if somebody's basically run out of money and they need help paying for their care, the rules on gifting in Medicaid, they have their own rules. So if I make a gift that is $17,000, totally permissible, for estate planning purposes, if I'm applying for Medicaid or my wife is, and we've been doing those gifts to our kids, we would have to disclose those gifts when we were applying for Medicaid if the gifts had been made within the previous 5 years. Okay? So I'm giving you the IRS and the tax rules on that. There's another set of rules that I like my clients to be aware of, and that's the Medicaid rules, because we end up doing a lot of work in that arena. Okay? All right, so let's talk about paying for long-term care, and where are we now? Are we got 20 minutes? We can do this. Okay. So the last section we're going to talk about, and hopefully, I think this is important for us to think about ahead, rather than just, when it's upon us, try to figure out what the heck to do. But it can be a bit of a dry topic, so I'm sorry. The other things we've talked about tonight were pretty exciting, right? You were laughing there. This, we'll try to spice it up a little bit, okay? So paying for long-term care, which hopefully, we all hope that we get to live in our homes until we go. And, that happens for some people, but a lot of people it doesn't. So we need to kind of be thinking about that ahead. The first thing there I want to kind of dispel is that Medicare, and probably most of us in the room, now there's some people younger than me, are on Medicare now. I have been for over a year. Medicare isn't going to pay for long-term care for a long time. Medicare will only pay for that for a pretty short period of time, where you've gone into the hospital, you've been there for 3 days, you've been discharged to a either skilled nursing facility or rehab type facility, and you're needing that skilled care or rehab. And Medicare, and if you have a Medicare supplement, they're going to pay for up to 100 days, and they hardly ever pay for 100 days, is my understanding and experience. And when they quit paying, then you're paying, and Medicare is not going to pay anymore. So if you are in an assisted living facility or foster home, Medicare is not going to pay that for the long run. So we need to be aware of that. Every once in a while, I have a client with long-term care insurance. Most people don't, so don't feel bad if you don't. You're in the majority, not the minority. But I always ask that because if a client has long-term care insurance, then depending upon the terms of the policy, that may be, really helpful in taking care of that long-term care and the cost of it. I really think that long-term care insurance is that's protecting your estate is what it's doing when you have that, okay? And I am not the expert on that, but always ask that question. If we have long-term care insurance, then we want to tap into that first if we have a spouse or a parent that's gone into long-term care. If Medicare's not going to pay and we don't have long-term care insurance, then we're paying privately for that care until we qualify for Medicaid. And if we have a substantial estate, we're not ever going to qualify for Medicaid. And frankly, you don't really want to, because Medicaid's a program where there's lots of rules. And boy, I tell you these days, I don't know what you're hearing, but I know my clients are really experiencing a pretty difficult process of getting their spouse on Medicaid or a parent on Medicaid. It's just really been more difficult with kind of this new one system that they have implemented. So, but if we need it to pay for our care, then you've got to go through that process, and you've just got to be, I tell my clients to be politely persistent and be politely persistent and be ready to be on hold for quite a long time to get that appointment. So let's talk, the last thing we're talking about here today is going to be, what's it take to become eligible for Medicaid? And if you have a retirement account with $1 million plus in it and a fully paid for home and a vacation property, this is when you should leave, because you're not going to have to know about Medicaid unless you're helping somebody else that might need it. If you don't fall into that category, it's good to just know what the rules are. So that's what we're going to cover for our last thing here today. What does it take to be eligible for Medicaid? And we're talking about the context of being in long-term care. We are paying privately, but we're going to run out of money, so we need to know how to qualify for Medicaid. So the eligibility requirements for the person applying for Medicaid is that their fixed monthly income, there's a limit on what that can be, and that limit's in your outline. It's $2,742 per month. We're looking only at the income of the applicant. So if I'm going into care and my wife's at home, they're looking at my income. And they're going to be looking at my fixed monthly income, my Social Security, and if I have a pension payment, that's usually what you're looking at. They're not going to look at my retirement account earnings or that type of thing. They're looking at my fixed monthly income. If you're over that $2,742 per month, which, it happens, then we have to do something called an income cap trust. That's not like the revocable living trust that we talked about. An income cap trust is something we only do if somebody has to go into Medicaid and their income's over that $2,742 per month, okay? The applicant, Medicaid divides your resources into countable resources and non-countable resources. So in my situation, I have a home. If my wife can live in it, but I have to go into care, they don't count the home. It's non-countable. I have a real fancy minivan that's out in the parking lot, okay? Your car, that's kind of a joke. It's an old minivan, and one car does not count. It's a non-countable resource. If I have the minivan and my wife has a real fancy car, they're going to count one of the two cars. You get one car that's non-countable. So your home's non-countable, your car's non-countable, and then all your stuff, all our furniture, furnishings, they don't really, they do not count that, okay? But the money in the retirement accounts, the money in the bank, if you have a life insurance policy with cash value, pretty much anything that you can easily turn to cash, they count it. They don't care if the retirement account is in my name or my wife's name. They're throwing it all into one pot. If you have property other than your home, it counts. The home doesn't count. And the person that's applying for Medicaid, they cannot have more than $2,000 at the time they apply if they're going to be eligible. That's the second requirement. We're going to talk briefly about what the other spouse gets to keep as far as those countable resources here in just a minute. They don't make you spend everything down to $2,000. The spouse that isn't needing Medicaid has an allowance that they get to keep. And then the third requirement they look at is an impairment level, and if you're into this and you want to know more, this handout that looks like this is out on that desk on your way out. You can grab one, and this gives you the applicant has to fall into one of these top 13 impairment levels. They call them priority service levels. So if, for example, the applicant needs minimal assistance with mobility and assistance with eating, then they meet, the ninth requirement, and that's all we have to meet, okay? And Senior Services is the program in Lane County that administers this, and they're going to do an evaluation to see where we are, okay? So if you have somebody that's run out of money, but they don't really need much help, they're pretty independent, they're not going to qualify for Medicaid. They've got to meet one of these top 13 priority service levels, okay? So again, just recap. Our income of that applicant has to be below the $27.24 per month limit, or we have to do an income cap trust for them. And remember, we're only looking at the applicant. The community spouse might have $5,000 a month income. They get to keep it all. That doesn't enter into the calculation. But on the resources, the applicant can't have more than $2,000. We're going to talk about what the spouse gets to keep here in a second. And then they have to meet that impairment level. And then they go on to Medicaid. And basically what Medicaid's going to do is that applicant's income is usually going to help pay for their care, and then Medicaid's going to pay the rest of the bill, okay? Which is huge and a big help for clients, especially that have, modest income. All right. Pretty quickly, we're going to go through what does the community spouse, the spouse that doesn't need Medicaid, what do they get to keep? So I already said this, but they get to keep all of their income, okay? So if their income is $5,000 a month, they get to keep it all. The rules do not require them to help pay for the care of their spouse. I find that a little unusual, but that is the way the rules are, okay? I don't think they let you pay even if you want it. It's just the way it gets calculated if somebody is on Medicaid, okay? If they have minimal income, then they'll probably get some of the applicant's income so that they have enough money to pay their bills. So if I have the spouse at home only has $1,000 a month Social Security and that's it, and they're living in their home, that's not going to be enough to be able to pay for the utilities and the taxes and the upkeep. So they're going to get an allowance, and the outline tells you there, the minimum allowance, as long as there's enough income to draw from, gets that community spouse income of about $2,300 a month. So in my example, if that community spouse has $1,000 a month Social Security, they're going to get $1,300 a month from the applicant's income so that they've got enough to be able to pay the bills at home. And then the applicant's income, the rest of it's going to go to help pay for their care, okay? So that's a good rule that, the state recognizes the community spouse has got to have enough money to be able to pay for their bills so they don't go on the system, kind of, okay? The resources that the community spouse gets to keep, this is a little bit complicated, and we're at the end of the talk, so you got to wake up for just a second. They get to keep half of the countable resources, but there's a maximum and there's a minimum, okay? So that's the good news. At least they don't only get to keep $2,000 like the applicant, that's all they get to keep. So they get to keep half of the countable resources, but there's a maximum and there's a minimum. The maximum they get to keep is about $150,000 right now, okay? So if we have $300,000 in the bank, the community spouse gets to keep $150,000, the other $150,000 has to be spent down to $2,000, because that's what the applicant can have is $2,000. If we have $100,000 in the bank and that's it, countable resources, $100,000 total of countable resources, they get to keep $50,000, because that's half, and that other $50,000 has to be spent down to the $2,000. The minimum amount right now, and I didn't put that in your little notes there, is there's a minimum amount of resources they get to keep is $30,000. So if all we have in the bank is $30,000, the community spouse gets to keep it all, which makes sense. They ought to have some savings to be able to, pay for emergencies and what have you. And if we have a lot in the bank, let's say we have $400,000 of countable resources, then because of that limit, they get to keep 150. They don't get to keep half, right? Because half is 200, and that's way over that limit of 150. So again, the rule is they get to keep half of the countable resources, subject to that maximum of 150 and the minimum of 30. And if you are helping a parent or a spouse with Medicaid, you really want to get some individual advice about what to do, because when we come to that spend down of whatever has to be spent down, you just need to know what the rules are, because you're going to spend money on care to get your spouse or your parent into a good care facility, but you also can pay off the loan on the car, or pay off the mortgage on the house if you have one, or pay off credit card bills. That all is an acceptable way of spending down the applicant's 1/2 share of those resources. So it's an area where if you're helping somebody to get onto Medicaid, you really want to know what's okay and what's not, so that when we get them on Medicaid, we have put the community spouse in as good a position as we can financially. So again, we have less of a chance that they're going to need that financial assistance down the road. Yes?
And this isn't working, so can you
Oh,
just repeat the
yes.
Is the person who is on Medicaid able to keep a burial fund?
Yes. The question is, can the person going on to Medicaid have a burial fund or keep it? And the answer is yes. Not only the person that's going on to Medicaid, but their spouse. So that's one of the things that I tell clients in that situation is, we're spending down. You want to make sure you have a pre-need plan paid for and taken care of for both spouses. And it needs to be, when you're going on to Medicaid, it needs to be irrevocable, so that you can't cash it out and turn it to, cash. So that's a good question, and that's the answer. And I always tell clients to have that in place. Otherwise, the surviving spouse is going to pay for that, or the kids are going to pay for it. That is what we call a non-countable resource, like the house and the car and your personal property. Other questions? Yes, sir.
When you're counting community resources, does it matter whose name the asset is in?
So the question is, when we're counting the countable resources, when we're figuring out how much we have, does it matter whose name it is? Not when we initially count it. It all goes into one pot. So if the one spouse has everything in the retirement in their name, and they're the one needing Medicaid, it all goes into the pot, okay? Or if they're not the one needing Medicaid, it all goes into the pot. Then what happens is we figure out what has to be spent down, and when we get spent down to the $2,000 for our applicant, and hopefully the $150 that our community spouse gets to keep, then at that point, applicant goes on to Medicaid, and then they're going to tell you, you got 90 days to make sure that the $150 that's left is all in the name of the community spouse. So, like I said earlier, lots of rules, lots of things to follow. It's doable. I mean, our clients are doing it all the time. It's just, if you don't really need it, it's something that I would really like to avoid having to go on to Medicaid, or to have my spouse avoid it. But I have lots of clients that can't, so then we help them do it and try to do things, as financially responsible as we can. A last few tips and a couple comments, and then we'll see if there's any other questions. I've already said this. We're on our last page, page 4. Medicaid isn't for everybody. A client that comes in that's got, $1 million of countable resources, I just would really try hard to not go on to Medicaid in that scenario, okay? Before we start doing any spend down, get some advice so you know what you can do and what you can't do. Because we can't give, I get this question all the time, can I just give some of my money to my kids? Well, you can, but you're going to have to disclose that when you apply for Medicaid if the gift was made within the last 5 years. So usually that kind of a gift is just going to cause a problem. If you're going to do any gifting, you want to get some advice before you do that. Same with, the spin down. And then when you're placing your spouse or your loved one in a care community, you want to make sure they do take Medicaid. Most places do, but not all do. So you want to make sure that if we need Medicaid, we don't have to move them to another place. Plan on initially being private pay because that will allow you to get into the care community that you want to get into. If we're going in on Medicaid, you're going to probably be more limited in your options, okay? And the last thing, and this is one of the worst things I'm going to tell you, is that if you go on to Medicaid, the state's going to keep track of that assistance, and after that applicant and their spouse, if they have one, has died, then the state's going to try to recover that assistance out of their estate. So if there's a family home, they're going to make their claim against the family home. And so that's another reason why we don't want to go on Medicaid unless we need it. And if we do need it, it's a great program, helps, thousands and thousands of people in Oregon, and it is really like an interest-free loan. If they do recover what they've paid out, they don't get interest on that unless they get paid way, way after the clients have died. So I think we'll wrap it up there and see if there's any questions about Medicaid, and then if you have other questions that you want to ask, I'm happy to stay here as long as we need to. Yes, Abby.
So, and there's 3 more minutes. Question from the streaming audience is,
Okay.
do people get divorced over one needing to go into Medicaid?
Not, so I don't have to repeat that. Okay. Not very often. I think I've been practicing for 40 years and doing Medicaid counseling for probably 25 to 30 of it. And I can remember a couple of instances where it made financial sense to do it. It just usually doesn't make sense. If you do a divorce and it's a long-term marriage, your assets are going to have to be split equally, including your home. Okay? And if you don't do that and we give all the assets to the community spouse, the state has caught on to that, and they will disqualify that person from Medicaid. They'll treat that as a gift, and it'll be a disqualifying divorce. So that does not work. It used to. We never did do that. I can remember our firm doing a divorce where the people actually really wanted to get divorced, and there were some significant retirement accounts that were going to have to be cashed out to get this person onto Medicaid. And it was done really for those types of reasons. So not very often would I recommend that, okay? And I do get asked that question a lot. Sounds like a good idea, but it doesn't usually work very well, okay? Any other questions on the Medicaid or the long-term care stuff? Okay, we've worn you out, and we finished in an hour and a half. If anybody, thank you. Okay, good. Well, hopefully it was helpful, and if nothing else, you've got a little more knowledge about some of those tools that really we all need to have in our tool bag. And if you don't have them, go to your lawyer, talk to him about it, and get those things in place. And you'll have hopefully a little more education to be able to talk with them intelligently about things like wills, trusts, powers of attorney, and healthcare directives. So thanks a lot. And if you have a private question you want to ask, I'll stick around afterwards, but probably we need to get everybody home. Okay? All right. Thanks again. Thank you so much, John. You bet. Okay. You're very welcome.